Good afternoon, friends. So what I'm going to discuss today is about the amnesty scheme, which has been issued with respect to waiver of interest or penalty if the demand has been issued under Section 73 or an order has been passed under Section 73 for the period of, for the period 2017, 18, 18, 19, and 1920. So Section 128 capital A has been inserted in the GST Act, which gives the benefit of amnesty from the waiver of interest and penalty for the periods 17, 18, 18, 19, 19, 20. Now, there is a notification 21/2014, which has been issued and which says that if the notice has been issued under Section 73, then within 31st March of 2025, the tax is required to be paid. And in order to avail the benefit of the scheme before the June 2025, a form, an application in prescribed form will have to be made to get the benefit of the offer. Now the question arises with respect to the demand under Section 74, and by virtue of a court order or the appellate authority's order or a tribunal order, demand under Section 74 is converted to demand under Section 73. Now we know that in most of the cases, invariably the department issues demand under Section 74, even if there is no ingredient of Section 74 is satisfied. And the ingredient being that there must be misrepresentation of fact, there must be deliberate intent to evade tax or commit a fraud. Unless and until all these ingredients are satisfied, Section 74 cannot be invoked. And there is a very wide jurisprudence on this particular aspect, that mere non-payment of tax does not signify the invocation of Section 74. There are judgments in the context of Service Tax Act and Central Excise Act that the allegation of fraud or malified intent is very serious nature, and the onus is on the person who is alleging. So there is a very high onus on the department and very high threshold to overcome the requirement of Section 74. Moreover, if it is the issue is an interpretation of law, or suppose the department is already aware of the fact, then Section 74 cannot be invoked. So there are many cases where ultimately a demand made under Section 74 may ultimately be converted into Section 73 demand by virtue of appellate court or appellate authority's order or court's order. Now, in those cases, Notification 21/2024 says that within 6 months of the issue of the order, whereby the order under Section 74 is converted into a 73 order, the tax may be paid, and subsequently an application in prescribed form may be filed to avail the benefit of the scheme. So the time period for making payment of the tax is 6 months from the date of the order, which redetermines the demand issued under Section 74 to make it a demand under Section 73. So this is with respect to 74. So it is not that those against those who have the demand has been issued under Section 74, benefit of scheme is not available, it may not be available today, but as and when one contests and succeed, so demand may be converted into a Section 73 demand. So wherever any such demand is there, one can approach the writ court also, because this particular issue of invocation Section 74 is a issue of jurisdiction, and the issue of jurisdiction can be preferred before a writ jurisdiction also, or a writ court also. So one may avail the writ remedy also to get a expeditious disposal of the matter. Secondly, one dispute or the doubt which has arose, that doubt has arose because of the circular number 238, which has been issued to clarify various doubts or the issues which arose with respect to availing the benefit of the scheme provided under Section 128 capital A. Now, in the table in paragraph 4, wherein various issues about, say, sixteen issues have been clarified. In serial number 4, one of the issue which has been clarified is whether the benefit provided under 128A will be applicable in cases where the tax due has already been paid and the demand only pertains to interest or penalty. Now the clarification says that yes, even if the tax has already been paid, the benefit of the scheme is available. But it says that it is not available if the demand of interest is on account of delayed filing of the return, as such interest is related to demand of interest on self-assessed liability and does not pertain to any demand of tax dues and is directly recoverable under Section 12 of Section 75. Now, in my opinion, this is totally contrary to plain reading of Section 128 capital A. Section 128 capital A nowhere says that the benefit of the scheme is not available if the demand is on account of the delayed filing of the return. So therefore, in my opinion, this particular clarification which has been issued is liable to be struck down. And I am very hopeful that in the time to come, it will be struck down by the court. There are several matters which are pending before Honorable Calcutta High Court, where this particular uh, clarification, which says the benefit of the scheme is not available for delayed filing of the return, has been challenged. The matter is not yet heard, and as and when the matter is heard, I am hopeful that the SECs will get a favorable relief. And even in those cases where the demand of interest and penalty has been raised due to delayed filing of the return, the benefit will be approved. So with this, I conclude my today's session. Thank you very much for joining.